Honorable Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you and welcome everyone. As you can see, I'm not Chief Justice Newby. I'm Senior Associate Justice Robin Hudson. Justice Newby is recused in this matter. I'm calling at this time case number 436PA13-4, Lake et al. Versus the State Health Plan for Teachers and State Employees et al. And we'll hear from the appellant.
Thank you, Your Honor. Your Honors, my name is Sam McGee. I am one of the attorneys for the plaintiff class. I intend to reserve 7 minutes of my time for rebuttal. The rebuttal will be handled by co-counsel Michael Carpenter. Your Honors, we are here in this case first and foremost to ask this court to adhere to its own precedent, which has held that the relationship between the state of North Carolina and its vested employees and retirees is one of contract, that deferred compensation is contractual and cannot be taken away, and that vested rights are contractual and cannot be taken away. The class that you have before you has been defined in a way that everyone in the class are people who met whatever requirements were laid out for them to be able to receive the state health plan premium free in their retirement. As this court said in the Falconberry case, you looked in that case at requirements for disability pay, and you said that when they meet those requirements, the contract is formed. Similarly, in the Simpson case, which was adopted, quoted, and approved by this case in both Bailey and Falconberry, you said the agreement to defer the compensation was the contract, and that fundamental fairness also dictates this result. What this court said in that case was that when state employees are promised certain benefits in exchange for their continued loyalty and service, and when they've been promised these things over time, and they do the work that's asked of them, they are vested. Those are their rights and cannot be taken away. If we look at the Bailey case, which again had to do with the tax deferred status of pension benefits, this court said that we look to the totality of circumstances to determine whether there was a contract between the state and its retirees. So that means we can look both at the statute and at matters outside the statute, what we'll call extra statutory materials. We talk about those a lot in our brief, but I want to start with the statute itself because there is a lot in this statute that demonstrates contractual intent. First of all, the premium-free nature of the state health plan is set forth in the statute itself. Second, the 5-year requirement that you have to work the 5 years to vest into that plan is also in the statute itself. Third, there is an undertaking clause, as we have cited in our brief, which says that the state undertakes to provide this plan that will pay these benefits. And as we've cited in the brief, that is mandatory language. One does not undertake a gratuity or a charity. One undertakes an obligation. A fourth thing in the statute itself is that the statute requires that any auditors that are required to look at this health plan follow the Governmental Accounting Standings Board rules and regulations. Those state that this must be defined as deferred compensation, which this court's cases say is contractual, and also that it must be booked as an obligation of the state of North Carolina. In addition, Your Honors, to those things from the statute, there is also where this is in the general statutes. It has been made very clear, particularly in the Bailey case, that the relationship between the retirement system and the retirees is a contractual relationship. That was a case that arose out of pensions. So this state health plan statute comes from the same chapter of the general statutes, chapter 135. And they're so intertwined that you have to be receiving the pension to be able to get the benefit. In fact, in the definitions section of the state health plan, that's how employee is defined, as someone who is actually receiving the pension. When they started charging premiums on the state health plan in 2011, which was the genesis of this lawsuit, they deducted those premiums directly from the pension payments that were being paid to the retirees. The 5-year vesting requirement is the same in both statutes, and that's the same 5-year vesting requirement that led this court to find contracts in both Falconberry and Bailey. And then finally, the same booklets and letters and materials that have gone out to explain to this class what their health benefits often were equally applicable to the pension statutes where you've already found a contract. There have been times, Your Honors, in this case where it appears that the state wants it to seem as though we're asking you to do something radical or surprising, that we're asking you to find some new contract that has not been found. What we contend, Your Honors, that you have already found that this relationship between the state and its vested employees and its retirees is a contractual relationship. We're merely saying that this health plan is part of that. So as I said before, there are three things this court has said are contractual. One was the retirement system, and I've just spoken about how intertwined how this is a part of that retirement system, the state health plan. The second is deferred compensation, and the third are vested rights. Having already talked about the retirement system, I want to turn now to deferred compensation. In the Bailey case, this court said if a pension is but deferred compensation, then an employee has a right to it, and it was found to be contractual. Now, we've argued this case has been going on for 10 years. We've argued it in many different courts, we've argued it in many different ways. And every time I make this argument, it feels sort of obvious to me because it's so logical. Is the state health plan deferred compensation? Well, obviously, you're getting this health insurance in exchange for the work that you have provided the state. So it is in compensation for the work that you have performed. So it's compensation. It's just as obvious that it is deferred. You receive compensation while you work, and that's not deferred. The compensation that you receive in retirement after the work is over is by definition deferred compensation. So to start with just a logical point, Your Honors, if it's clearly deferred and it's clearly compensation, it is deferred compensation and should fall within this court's precedents that say deferred compensation is contractual. Now, it's not just logical, but also this court has addressed this issue before. In the, I don't know if it's pronounced Leet or Letty case, but anyway, it's a case of this court that are cited in our brief. This court had to address whether certain employee benefits were exclusive emoluments. That is, were they unconstitutional gratuities, or were they in fact consideration for work performed? And this court found, and specifically it listed several employee benefits, including insurance, and said that these are compensation for the work that has been performed. So in addition to this logic, it's within this court's precedent, as are really every issue in this case, is within this court's prior precedent, that this is in fact compensation. Third of all, as I've already mentioned previously, the GASB regulations are required by statute to be followed, and they define this as deferred compensation. And then fourth and finally, in this case, your benefits booklets, these are some of those extra statutory materials that this court has said should be looked at in this type of situation, in the Bailey case in particular. They'll have cover letters on them from treasurers. And the state treasurer has been from different parties at different times, but those letters have referred to this as part of the total deferred compensation package that you earn from doing your work. Now, despite all of this, everything from statutory requirement of how this is considered for accounting, to common sense, to this court's precedent, to even admissions by state officials, the state still claims that this is not deferred compensation. Now, in their brief, what they do is they substitute in the word compensation that was used in the Bailey case and other cases in this court, and they instead use the word salary and say that it's not compensation, that deferred compensation that is contractual, but it's only deferred salary. And in some ways, Your Honor, the Court of Appeals sort of follow this. They said, well, pensions are based on your years of service, your amount of pay. They're paid in periodic payments. And those are things that are more like salary. The problem is that this court's precedents have never relied upon that kind of distinction. Think about the tax-free nature of pensions. That applied across the board to all pensions, no matter how long you've been working, how much you've been paid. This court also looked to Bailey and Falconbury when it was deciding the NCAE case, which dealt with teacher tenure. Teacher tenure is obviously not something that's paid out in periodic payments or based on your rate of pay. So there has never been a precedent of this court that said only deferred salary is deferred compensation. What this court has said is deferred compensation is contractual and cannot be taken away. Now, one thing that the state does is look to the definition of compensation in the pension statute, which, as we've noted in our brief, is a definition that is used in order to determine how pensions are going to be calculated. And if we were to look at that definition and apply it in this context, where we're saying what is or what isn't deferred compensation, it would lead to multiple absurdities. But as a matter of time, I'll just look at one of those. One of the things that is excluded from that definition of compensation is contributions to deferred compensation plans. So if this is the definition we look to determine what deferred compensation is, as the state requests, that would mean literally that deferred compensation is outside of the definition of deferred compensation. And that is exactly the kind of absurdity that this court has always sought to avoid in statutory interpretation. So much as this retirement health benefit derives from the retirement system and is interlinked with the pension system, which has already been found to be contractual, it is also contractual because it is deferred compensation. The third thing that this court has said in its cases that is contractual, cannot be taken away, is vested rights. As I said in opening, in the Falconbury case, when the state issues certain criteria to its employees and says, you do this amount of work, you get this benefit, and the people respond by getting up every day and going to work, they have accepted that unilateral contract offer from the state. And at that point in time, they are vested. It is exactly the same 5-year vesting here for the majority of our class. Prior to 1988, you just had to retire, but then there was a 5-year vesting requirement. But everyone in this class has vested with whatever the vesting requirements that were there for them at the time that they reached those requirements. So we've talked about how much of this comes from the statute, but when it comes to vesting, I do want to talk about some of these extra statutory materials. There is a mountain of evidence in this case that everyone understood this was vesting. There is no mystery about this. There is no serious question about this. Everybody knows that what these people were told was that if you meet these vesting requirements, you will get the regular state health plan premium free throughout your retirement. The executive director of the plan has testified in her deposition in this case that she believes she is vested. The state treasurer, or who was the state treasurer at the time of the deposition, has testified that she believes that she is vested. The language of vesting was also in the training materials for the benefit counselors. These are the folks whose job it was to tell the people in our class, here's what the deal is, here's what's required of you, and here's what you're going to get. Those use the language of vesting. The actuarial reports that are required by statute that each year looked at this plan have talked about this as vesting. You work the time, you're vested. Press releases from the state health plan itself have talked about you are earning this through your work and it will be vested once you have worked for 5 years. So this is what was actually sold to the class. In the Bailey case, Justice Lake talked about how unfair it was to think that the state would get the benefit of paying lower salaries to state employees because of the promise of higher benefits. I was born into a household where there was a man that worked at a community college and a woman that taught kindergarten. State benefits were talked about a lot in my house. Justice Lake in the Bailey case talked about how unfair it was that you could pay that lower salary because of the promise of higher benefits. And then when you get to retirement, say to the people who did what you told them they would have to do to get the benefit, you're not going to get that benefit. The budget is tight. We're taking that away. What our courts have found in all the cases we keep talking about, most notably probably Bailey, Simpson, and Falconbury, but others as well, and many in the Court of Appeals that didn't make it up to your honors, is that rights, once vested, cannot be taken away. So I would submit to you that all three of those are must-wins for the defense. If this is part of the retirement system that's already been found contractual, there's a contract. If it's deferred compensation, there's a contract. If these are vested rights, there's a contract. If we win on any of these three, we should win on the issue of whether there was a contract. I would submit that we should win on all three. So I'd like to move on to what is this contract? How was it breached? And what are we supposed to do about that now? The contract, in its simplest form, is that everybody in our class vested into the regular state health plan, which was required by statute to be premium free and to be provided throughout their retirement. So what was the breach of that contract? The breach happened in 2011. When the state health plan came into being in 1982, from then until 2011, there was always a regular state health plan. At times, it was the only state health plan, but the statutes did allow at times for there to be optional plans. The regular state health plan had to be premium free. The state did have the option to offer optional plans, and premiums could be charged on those. So there were various changes made to the plans over the years, and I'm going to get to that issue. But everyone in this class vested into that regular state health plan and were receiving that regular state health plan premium free. Now, here's what happened in 2011. For the first time ever since the beginning of the state health plan, what these folks got told is, for you to keep getting what you already have been getting, you're going to have to pay for it. And the only way you're not going to pay a premium is you're going to have to voluntarily move into an optional plan that has a lower value. So the default throughout the history, just as the statute requires, had been premium free. And all of a sudden in 2011, the default now is you're paying a premium, and those premiums have been paid into 9 figures. So that's the catch-22 that was laid out. If you want to keep getting what you've already been getting, you got to pay. If you want it to be free, you have to take something of lesser value. And when I say it's of lesser value, our actuary has shown it's of lesser value, their actuary has shown it's of lesser value, and the executive director of the plan has testified in her deposition that it is of lesser value.
Is there a question of fact as to whether what is available premium free now is functionally equivalent to the pre-2011 no contribution option?
So I don't believe that there is an issue of fact as to that, Your Honor. I do believe that what the trial court has done is set forth the manner in which the damages will be calculated. So I think that any changes to the plans that have been made after the initial breach that may affect what the damages are will factor into how the damages are calculated. But what we know for sure is that the regular state health plan never had a premium on it, and that plan that most people just defaulted into, suddenly they had to pay a premium for that plan.
If I'm understanding your argument, Mr. McGee, it is in effect that the 80-20 plan and what you refer to as the regular state health plan are synonymous. Is that in essence what you're arguing? So
that's true. And so really, I think the best way to answer that is to talk about what the trial court did. The trial court essentially said two things. Said everybody had vested into that state health plan, which was an 80-20 plan as of the time of the breach in 2011. And so the court did two things. Number one is to say those premiums weren't allowed to be charged on that plan, and they are a damage. That's number one. And then number two said, well, it's one thing, we got to make sure that they get their premiums back because they weren't supposed to pay them, but also we have to make sure that they get the benefit of their bargain. So everybody had vested into and accepted the plan as it existed at the time of the breach. So the trial judge had to decide, how do we get people back to where they were before the breach, which is what breach of contract damages are supposed to do. And so the way he did that is to say everyone is entitled to a plan of the value of what they had vested into and accepted as of the time of the breach in 2011. And that's where he said in the future, we will look at the plan that's being offered to them. It's got to be premium free, and it has to be of that value. That's a little bit of a long answer to your question, Your Honor, but the reason I say it that way is because, when you can make a change to a health plan, you can even change the co-insurance rate, but that might not affect the overall value of the plan because there might be offsetting changes that maintains the entire value of the plan.
But is there an issue of fact as to the overall value of what's available now as compared to what was available before 2011?
I think that I do not believe that there's an issue of fact that to compare whether the plans that existed at the time, whether the plan that everyone defaulted into was a more valuable plan. So what the judge has said, I don't think there's an issue of fact because he takes care of that in the remedy. Because what we know, because everyone has agreed that the 70-30 plan that was premium free as of 2011 was a less valuable plan. We know that. But in terms of going forward, have they improved that situation? A is a damages issue, which is the premiums are easy enough to deal with. But the injunctive relief part also gets handled in the remedy portion of this, because what happens is every year the state's already required to do an actuarial analysis, and so the state will be required to compare that to the plan that we know what its value was. So each year the state has to compare the plan they're giving to the retirees under the injunctive relief to 2011, and we know what that value was. So I don't think that creates an issue of fact, because it's future plans have to be compared to a static point in time when we know what the value of that plan was in 2011.
So under your argument, does there have to be a new evaluation every year of whether a violation has occurred?
Yes, I mean, I believe that the trial court's order would dictate that. There already has to be an actuarial analysis of the plan on an annual basis anyway, based on the statute. I'm happy to continue speaking on those points, but I want to mention a couple of other things because I'm going to run out of time. One of the things that the state
and Mr. McGee, well, before you go on, you didn't say, I don't think, if you wanted to reserve time for rebuttal, and you manage your time the way you want, but you might want to let us know if you're going to do that.
Yeah, my intent is to reserve 7 minutes, so I'm getting right up on it, but I'm gonna do the best I can. So let me speak about the right to amend and the amendments over time, because those are issues that the state has raised. And I'll tell you what, let's talk about the right to amend. The cases that have come before this court before, in this employment context, invested rights context, that have addressed situations where there's a right to amend, have still found a contract. There was a right to amend in Simpson. There was a right to amend in Falconbury, and this court found contracts in those cases nonetheless. Rights to amend.
Does the content of the right to amend provision make any difference in the outcome?
Well, there is some limitation on that right to amend in those cases, but it's interesting that the Simpson court actually excised out those words that were limiting. It considered it as a general right to amend. But I would state, Your Honor, in answering your question, that in any event, rights to amend always have to be read in concert with vested rights. This court addressed that issue in the context of corporate charters, where there is a very broad right to completely do away with a corporate charter. But the Elizabeth City case of this court said, well, that may be the case, but you still can't take away contracts that have already been formed or rights that have already become vested. There's been some talk of the federal cases in this context, but also there, Your Honor, the sinking fund cases, which both sides have cited, say you cannot undo what's already been done. You cannot unmake contracts which have already been made. The state has essentially tried to contend that you just can't form a contract if there's a right to amend, because then everybody that deals with you knows that there's no way that they can form a contract with you because this can be amended. The problem that would cause, Your Honors, is that argument would apply equally to third parties like Blue Cross Blue Shield, insurance companies, medical providers. If the employees are doing business with the state knowing that they have no guarantees of anything, that would be the case with third parties as well, which again would be the kind of absurdity that we have to try to avoid. There's also been an argument about there being a lot of amendments being made over time, and a couple of quick points on that. First of all, that does not distinguish this case from the pension cases. If you look at the pension benefits section of that statute, it's been amended up to, I think, section WWW, and that's with some of those being multiples, like I think it goes all the way up to B20 something. So the pension statutes that have found to be contractual have been amended even more than this one. Most of those amendments are irrelevant to what we're talking about, because they were either administrative challenges that didn't change the benefit of the bargain, they were prospective only, or they increased benefits. The only changes that would be relevant would be changes that were both retroactive and reduced benefits. The problem for the state there is that we went to summary judgment. If the state wanted to raise a defense that there had been amendments that had reduced the benefit before, they should have brought evidence for that. That's done by actuarial analysis. And although both sides had actuaries in this case, they primarily looked at the plans coming from later dates, and they did not go back to various changes from years and years ago to say whether or not they reduced the value of the plan. even if there had been some previous amendment that had lowered the value of the plan, it would not necessarily indicate a lack of contractual intent. One breach doesn't forgive a future breach. And what we know is there had never been a premium charged on this plan. And I'll also say this, Your Honors, unfortunately, the argument that the premise of that argument is that the state would not breach a contract if it had one. And sadly, this court has heard Bailey and Simpson and Falconberry and NCAE and the Court of Appeals has heard Bullock and Pritchard, and this court has heard Wiggs, and it appears the state generally will test the limits of its agreements. So I believe we may be beyond the time where we can assume that because they did something, that means they had the right to do it. Your Honors, I'm down to 5 minutes, so I'd like to reserve the remainder for rebuttal.
Mr. McGee,
Yes, Your Honor.
we'll hear from the appellant. Appellee, sorry.
Thank you, Your Honors, and may it please the court. I'm Ryan Park from the North Carolina Department of Justice, and I'm pleased to represent Treasurer Falwell, the state health plan, and the other state defendants in this case. For at least 4 reasons, the Court of Appeals was correct when it unanimously held that plaintiffs had failed to prove that they had a contract right to premium-free health benefits at a fixed level for the rest of their lives. First, this court's precedent requires plaintiffs to show that the General Assembly made an explicit, unequivocal, and unmistakable expression of its intent for the statute to be a contract. Plaintiffs have failed to identify any expression of legislative intent of this kind, let alone one that overcomes this court's strong presumption that statutes represent policies that can be changed over time and not contracts. Second, the General Assembly expressly reserved the unlimited right to amend the health benefit statute, and it has been black letter law for more than a century under precedents from this court and the U.S. Supreme Court that clauses like these give, quote, special notice of the legislature's intent not to create contract rights. And as this court squarely held in Adair, even if there were a contract here, the right to amend provision would itself be a term of that contract. This term would expressly allow the General Assembly to make the kinds of changes that are challenged in this case. Third, the non-statutory materials that plaintiffs cite cannot establish as a matter of law a contract. As Justice Irvin explained in the McCaskill case, agents of the state cannot enter contracts that bind the state without express statutory authorization. And no statute authorizes any state agency or official to offer contracts for retirement health benefits to state employees. Fourth, even if plaintiffs had established a contract of some kind, plaintiffs have failed to show that the contract's terms required a fixed level of benefits. Plaintiffs can point to nothing in the 20,000-page record that remotely suggests that they were promised health benefits with a certain actuarial value or that financial terms would never change, as they now claim. Nor could state employees have reasonably believed that health benefits were set in stone or that their financial terms would never change. The annual health benefit booklets that were distributed by the state health plan state emphatically and repeatedly that the General Assembly has the authority to change benefits, and they communicated the hundreds of changes that were made over the years, by our count 81 of which reduced certain value terms, including the 2 previous times that the General Assembly made the exact same change challenged here, which is a reduction in the coinsurance rate attached to premium-free benefits. And when the state first made this change, the state health plan informed retirees in the next benefit booklet of the change and explicitly warned them on the very first page of the booklet that benefits could be reduced further if healthcare costs continued to rise. And that's at document exhibit 1280. And finally, it's worth noting that there's never been any dispute that the state has always allowed plaintiffs to enroll in the same health plans, and usually more valuable plans, as is the case now, as active employees, including at least one plan that has always been premium-free. Nor has there ever been any dispute that the health plans offered to plaintiffs who are 65 years and older far exceed in value what plaintiffs say they are owed. So on the factual record here, plaintiffs cannot reasonably say that they've been treated unfairly. The state therefore asks this court to affirm the judgment below. So I'd like to start, if I might, yes, Your Honor. I'd like to start, if I might, on the right to amend, because we think that this provision is decisive in this case. This provision says the General Assembly reserves the right to alter, amend, or repeal the terms of the state health plan. The intent of this language could not be any clearer. As the U.S. Supreme Court has observed repeatedly, including in the National Railroad case that this court has cited in NCAE, when a legislature includes these words, it, quote, not only retains, but has given special notice of its intent to retain full and complete power to amend a statute without giving rise to statutory contract claims. This court, too, has on multiple occasions specifically addressed the effect of a right to amend provision on contracts clause claims. So in Adair, this case was from 1974, shortly before the statute in question here was enacted. This court said that, quote, when a legislature reserves the right to amend or repeal a statute, a charter, it retains the power to change the contract so that a later repeal or amendment does not result in an unconstitutional impairment of contract. And it cited U.S. Supreme Court cases, including Looker, for this proposition. So, and this is so in part, as the court said in Adair, because such clauses give, quote, ample notice to parties who otherwise might rely on the statute that the General Assembly intends to change the statute in the future. So the court in Adair then paired this principle with the rule that contracts incorporate relevant statutes that this court recited in NCAE, and it held that thus any contract that was at issue there would include as a term in the contract the legislature's right to amend as an implied term.
Mr. Park, what role, if any, in our analysis do our opinions in Bailey and Falconberry NCAE have?
Yes, we don't dispute that those opinions are relevant here, and we haven't asked for this court to reconsider those opinions. My understanding of this Falconberry line of cases, and I would direct the court to page 691 of the court's opinion, is that when it engaged in this deferred compensation rationale for deciding whether pension benefits are contractual, it was an exercise in attempting to discern the legislature's intent. It was responding to the state's argument that there was a lack of contracting intent, and it said, when there's a statute that has this structure, we can infer intent. And then it cited a contracts treatise, which was discussing how to infer that a contracting party has intent to contract. But here, there's no mystery as to what the General Assembly was trying to do. If you were a lawyer advising the legislature on how to draft a statute for a massive new benefit program without creating contract rights, I'd submit that your job would be fairly easy. You would simply look at the case law and find that there was over a century of precedent from this court, recent precedent, long precedent from long ago, and the U.S. Supreme Court that definitively stated that an unlimited right to amend provision with this very language, the right to alter, amend, or repeal a statute, forecloses statutory contract claims. Now, I'm a lawyer who advises government clients.
Is the state disputing that the benefit here at issue is deferred compensation?
Yes, Your Honor. So let me explain here. So we don't dispute that, in a colloquial sense, health benefits are part of someone's compensation. But that's kind of like saying, if I offer you a ride home, that's a contract offer. This court has established a legal test for what constitutes deferred compensation. And here I direct the court to the NCAE decision. And what it said is that when benefits are, quote, presently earned and not subject to any future contingency, then that's a deferred compensation scheme. And if I might, I'd like to correct my friend on the other side. Falconberry on page 691 says that that pensions are, quote, delayed salaries. The court in Bridges, the first case that addressed this situation, says the word, quote, delayed salaries. And that's because a pension is a unique system where you actually take, it's about 6% now. So 6% of our paychecks are deducted and put in a segregated fund and then given back to us during retirement. Now that's a delayed salary scheme. And it's not an exotic position at all to say that health benefits are not delayed salaries in this same way. That's what the U.S. Supreme Court has held multiple times in recent years, that under ERISA, this is quoting from M&G, a case we cite in our brief, that retiree healthcare benefits are not deferred compensation like pensions. And it goes on to say that because it's not an income deferral scheme, it's an optional welfare benefit under ERISA, healthcare benefits are not scored as deferred compensation. And the California Supreme Court just 2 years ago held this as much unanimously. It said, like I said before, you can use loose language to say something's an offer or compensation or vesting. But when you actually look at the legal definition of these terms, welfare benefits, like health benefits, are not like a delayed salary and therefore non-contractual.
My question may be at too high a level of generality, but I want to understand, you're essentially arguing that if it wanted to, the state could simply stop offering healthcare benefits entirely to retirees. And Am I right about that?
Yes, we think that the democratically elected branches of government have within their discretion the authority to make policy, including on massive benefit programs like these.
Right. And so if the health insurance for retirees is not something they contracted with as part of their employment, it's not a vested right, it's not deferred compensation, then how is it also not an emolument?
Well, thank you, Your Honor. I appreciate the chance to address that issue. So on my shelf back here, I have, Justice Newby's treatise with Professor Orth, and what it says is that emoluments are the test for whether something is an unconstitutional emolument is whether the benefit is for the public welfare. And the court has never said that everything is either an unconstitutional emolument or a contract right. And if that were the case, I would submit it would threaten a large parts of the modern benefit programs that the state has. Instead, what the court has said, and this is from Hinton, where there was a statutory benefit that was given to all veterans, and other cases that we cited in our brief, that as long as this isn't some special benefit, some special emolument that is given to a particular individual for a private purpose, then it's not unconstitutional and doesn't violate the emoluments clause. I'd also point out that that clause is called the separate and exclusive emoluments clause. And so it really is targeted towards government programs that, like in the Leak case, just gave a bunch of money to a former government official in appreciation for his service.
But isn't that, I mean, if we were to agree with you that health insurance coverage of any nature, whether there's a premium or no premium, if health insurance coverage is not part of a contract, not a vested interest, not deferred compensation, then it is only going to a certain subgroup of people who worked for the state of North Carolina. It's not like we're not providing universal health care, right?
Well, yeah. So, and I think I would be eager to defend that case if it ever came, and I think our defense would be that it is in advancing the public welfare to give statutory benefit programs, even non-contractual statutory benefit programs, to state employees, and therefore would not violate the emoluments clause.
Mr. Park, while we're changing people asking you questions, let me pose one to you as well. Let's go back to the right to amend discussion a second, if we could. If I understood your colleague's argument, they're saying in effect that even a broadly written right to amend provision like the one that is present in this legislation is not entitled to broad effect once a right has quote unquote vested. And that seems to be their argument. I understand it, and they can correct me on rebuttal if I'm misstating their argument, and I hope they will. It seems to me they're saying in effect that the right to amend is limited to the period between the time that the employee initially becomes employed by the state and the date upon which vesting occurs. And that once vesting has occurred, a broad right to amend does not exist. What's your response to that argument, assuming that that's the one that they're making? If they're making something different and I'm misapprehending it, please tell me that too.
So I think that is the general nature of their argument, and here's our response. So it's not consistent with the case law, and here's why. So in Adair, for example, there was in National Railroad, Bowen, there are many cases from the U.S. Supreme Court, from this court, where there was an unlimited right to amend and some statutory term that could have been seen as a contract right. That was a contract right. And what the Supreme Court said, when this court said in Adair, is that if that's true, if there is some sort of principle that statutory benefit programs or statutory rights are incorporated into a private contract, the reserved right to amend is a term in that contract. But there is a limit. There is a limit, and we agree that there is a limit. So, and this is the Elizabeth City case. This is the sinking fund case. So when there are third-party contracts that are authorized by statute, so in Elizabeth City, it was a private law, a local law, that authorized Elizabeth City to engage a third-party contractor to run its water system, that there are limits to the General Assembly's authority to impair that third-party contract. So here, the benefit statute authorizes the state health plan to contract with vendors such as Blue Cross Blue Shield to administer the health plan. And what the Elizabeth City rule and the rule that plaintiffs rely on here says that the state is limited in its authority to impair that contract, a real valid contract that you can pick up, that's signed by the parties, that has a list of terms. But what the general precedent is that when there's a right to amend provision in the statute itself, the statute is not a contract. And if it were a contract, then it would be subject to the right to amend.
So you're, again, to make sure I'm understanding you, Mr. Park, the reason that you are not persuaded by their argument in reliance on the Elizabeth City case is that there's no third-party contract involved here.
That's right. I mean, I think that there has been some confusion on, whether the statute is the contract or there's some non-statutory materials that create the contract. I'd point out that on page 19 of plaintiff's brief below, they said, quote, "The statute is not the actual contract." So I think this confusion comes from both sides. But what I would say is that if the allegation is that the statute is the contract, then it's subject to the right to amend, and any contractual being that could otherwise be formed is blocked by the right to amend. And that's the whole purpose of these clauses, because legislatures inherently have the authority to amend their statutes. There's no, unless there's some constitutional limit that blocks the legislature from acting, every statute is a policy that can be amended to address changing circumstances.
Let's assume that there's some other basis for contract other than the statute, because they make arguments based on representations of various state officials. What relevance, if anything, does the Elizabeth City decision have with respect to that set of circumstances?
So if there is, so we would agree that if there is some third-party contract that is authorized by statute, and I think one of the leading cases in this area is Your Honor's decision in McCaskill, then there would be a limit that would be placed on the state's authority to amend that contract. But then we're in the question of whether there's statutory authority for the retirement system, which is the pension agency, to offer health benefits to retirees. And if I may, I'd like to, I think, clarify some confusion in this regard. The retirement system, at all points relevant here, has been overseen by the treasurer, the Department of State Treasurer. And the state health plan, again, for all times relevant here, was ultimately under the supervision of the governor, under OSBM. These are entirely separate state agencies. And that's why the McCaskill case is so relevant, because we live in a divided executive, and often there are separately elected executive officials who administer these two separate programs. Often they're members of different political parties, and the governor has no authority to tell the retirement system how to structure their benefit booklets. And by statute, the retirement system, although it sounds like generally everything that has to do with state employee retirements, it's by statute limited to overseeing the state employee pensions for teachers and state employees. And so I think a lot of this loose logic that somehow, because something called the retirement system that does not administer health benefits, never has, and was housed in an entirely separate agency, can somehow bind this other agency essentially under the governor's supervision, is simply, it misunderstands the nature of North Carolina state government. And I'd like to direct the court to the benefit booklets that the state health plan has issued. I would strongly hope that you've looked at these, and I would direct the court as just an illustration. Document exhibit 1535, 1486, 1440. These are the first page, the very first page of the state health plan's benefit booklets. And I commend the lawyers advising the state health plan. It says, notice in all capitals and bold, the North Carolina General Assembly determines benefits for the plan and has the authority to change benefits. It includes in bold, all caps, entirely separate page at the very beginning of the booklet, that the General Assembly can change these benefits if healthcare costs continue to rise, benefits can be reduced. I do not know what more the state health plan could have done to inform plaintiffs, retirees, that benefits were subject to change. And again, I'd like to point out that the exact change that is being challenged here which is a reduction in the coinsurance rate for premium-free benefits, has changed twice before, in 1985, 1991. It started out 95.5, went to 90-10, 80-20, and now it's 70-30. And I would submit that plaintiffs have identified nothing. I would urge them to identify anything today that suggests that there's anything beyond a contract right or an implicit promise to enroll in the state health plan in its evolving forms. There is absolutely nothing where the plaintiffs have been able to show that there's a document or a record saying the financial terms won't change. You know, the coinsurance rate is set in stone. You know, it's now 80-20 and it has to remain 80-20 for the rest of your lives. And if I might, Justice Irvin, to address your question on the factual issues, you know, this gets a little technical, but I'll try. So plaintiffs say that there's a regular state health plan, and that regular state health plan is the major medical plan. That's the standard indemnity plan that has been offered from 1982 to 2008. The only evidence in the record is on document exhibit 132 on what the value of that plan was. This is defendant's expert report. And that value is 75%. So plaintiffs say, you know, the only way to compare health plans in a valid way is through actuarial value, this financial accounting metric. And the only evidence in the record after, again 10 years of discovery and fact finding is that in the year that the plan was terminated, the major medical plan was terminated, it was 75%. So then we see, okay, well, what is equivalent? If that's the contract rate that plaintiffs claim, what's equivalent to that actuarial value? And I would look at document exhibit 1097. And that is plaintiff's own expert report on actuarial values. And what it says is that their own expert concluded that the actuarial values of the 70-30 PPO plan that has been offered premium free to all retirees is above, at all times above, what the major medical plan was in the year it was discontinued. So we agree there's no factual question here in terms of whether there's been a breach. If you get all the way to this point in the analysis and the court concludes there's a contract right, then we think that plaintiffs have failed to prove their case. I mean, there is no evidence other than what I've described in terms of what the actuarial value of the major medical plan was. And I would just point out that it's a little bit strange that everyone agrees, this has never been in dispute, that terms like 80-20 refer to coinsurance rates. You know, that's the only way that statutes or the state health plan or the retirement system or any state official has ever used terms like that. I don't think there's any dispute on that. And so it's unclear why, if that is the contract claim, they say in their complaint, we have a contract right to an 80-20 health insurance plan, why they're not asking for an 80-20 coinsurance rate. As at least I understand, they have disclaimed any right to a contract of that kind. So if I might, I'd like to address this question of fundamental fairness, because you know it is an issue that I take seriously, that the state takes seriously, and I would submit that if you look closely at the facts here, there's no concern in terms of the state having reneged any promises or withdrawn any benefits that it represented it would provide. Again, today, there's never been any dispute that for anyone 65 years and older, they have a health plan that's premium free and it has a value that far exceeds what plaintiffs say they are owed. 90% actuarial value or more in these Medicare Advantage plans. And that's around 75% of the class. So then we are here talking about, for those plaintiffs, around 25% of the class who are under 64 or younger, whether the 70-30 PPO plan breaches the contract on some unsubstantiated value term where there's no evidence of, you know, a promise or representation from the state health plan, from the retirement system, that they would have a plan with an actuarial value above what the current 70-30 plan offers. You know, I don't feel uncomfortable saying that I don't think the state has ever broken any promises to any of the plaintiffs, and that plaintiffs, the current retirees, are getting a very valuable benefit. Their own expert estimated that the premium-free 70-30 plan is worth $6,500 annually. That's the premium-free plan. and the value of that plan is only rising as healthcare costs continue to rise. And in terms of what we're really talking about here, we're talking about the state trying to engage in responsible fiscal planning. The state spends around $3.5 billion annually on state employee and retiree health benefits. $3.5 billion. That's more than it pays for all of the regular operations of state government by a long stretch. And it approaches what the state pays for Medicaid to give health benefits to the low-income population of North Carolina as a whole. This is over 10% of the budget of all the expenditures that the state expends, and this unfunded benefit is increasing and increasing. It's currently estimated to be around $35 billion. It's to such an extent that the state was required to report this very case to its creditors as a potential subsequent event, one of the few subsequent events that could alter the state's bond rating in a negative way. And so I would submit that ultimately here, what we're talking about is democratic governance. Whether faced with these kinds of fiscal issues, whether the legislature has the authority to make modest changes to state employee benefit programs and decide to do that in lieu of raising taxes or cutting funding that it spends on other worthy programs like law enforcement or schools. This is fundamentally a policy question that the General Assembly has reserved its own right to decide. And I think as a lawyer who advises government clients in how to conduct their conduct in a way that avoids these kinds of claims from being raised, I would submit that it is rare for there to be a case that is this straightforward, where you can look up the doctrine and find a century of precedent from this court, from the US Supreme Court, saying if you include these words, the right to alter, amend, or repeal the statute, then you won't face claims like these. And I would point out that this phrase, alter, amend, or repeal, traces all the way back to Justice Story's concurrence in the Dartmouth College case. It's been inserted in statute after statute, including the Federal Social Security Act, which the US Supreme Court held in Bowen unanimously that there's no contractual rights to this federal Social Security because of this provision, because this claims any intent for Congress to create private contract rights. So if I might, I'd like to address one other question which has arisen, which is the relationship between the pension statutes and the health benefit statute. So if you look through the pension statute, I think you'll find contractual language that permeates the statute. It says that retirees, quote, shall receive benefits in accordance with a statutory formula 65 times. It says that pension benefits are vested 20 times. It says that if the pension system is terminated, then anyone who is a member of that system has a non-waivable right to receive back the portions of their salary that were deducted from their paychecks and put into the pension system. They can get it back. And with the state health plan, it has the exact opposite language. It says, if the plan is terminated, then it has, a series of steps that describe what the state health plan will do, but it does not say that retirees have a non-waivable right to those benefits. So to conclude, I would just leave the court with this. The state agrees wholeheartedly with plaintiffs on the importance of providing health benefits to them during their retirements. That's why the state has always provided them with the same or better health plans as active employees, and this is by statute, has guaranteed that at least one of these plans is premium free. Providing these benefits comes at considerable cost, and these costs have accelerated sharply. So ultimately, we think this case is about democratic governance. It's about who has the authority to decide how to spend these massive amounts of money that hamper the state's fiscal planning going forward. And the General Assembly could not have been clearer that it wanted to retain the flexibility to make these choices, by including an unlimited right to amend provision in the benefit statute. And I would implore the court to study the Adair case and the Spearman case, where the court said, several generations after Elizabeth City, that if there's a right to amend provision in a statute, and the statute forms a contract right, then the right to amend provision is a term of the statute, and it forecloses statutory contract rights. I don't think that there's any way for this court to reverse the judgment below without reversing Adair and Spearman, and without bringing this court into conflict with a century of U.S. Supreme Court precedent on the scope of the Federal Contracts Clause. The state therefore respectfully asks that this court affirm the judgment below.
Thank you, Mr. Park. Rebuttal?
May it please the court, my name is Michael Carpenter, and I'll, along with Ms. McGee, represent the plaintiffs' appellants. Just right out the gate, I want to address one thing Mr. Park said on behalf of the state. They said that health insurance benefits are very important for retirees, and they believe it's real important. The question is then why, through this case, have they sought to cancel those benefits, to make those benefits non-contractual, to make it so that they could end the benefits at any date or time, to provide nothing at all. That's the position that they've took. You heard them say that in their primary argument. So what's at stake in this case is exactly what we said in the PDR. All retirement health benefits in this state are at stake in this case. If the state has their way, the Court of Appeals opinion stands, they can take away all retirement health benefits tomorrow. There will be nothing left for all of these hundreds of thousands of people, not only who retired, but are getting ready to retire and hope to enjoy those benefits. And I think that's something that this court should take into consideration, as it did in Bailey and in Falconberry and in Simpson. Addressing some of the specifics on the right to amend, none of the cases that is cited by the state stand for the proposition that there's a difference between changes to a third-party contract versus a direct contract with the state. That somehow Elizabeth City was limited to a situation where you have two contracting parties and the state is a third wheel to that.
Mr. Carpenter, just so maybe I can get my own understanding straight, if nothing else, your contention, I take it, is that there is a contract between your clients and the members of the plaintiff class and the state, not so that there's no issue of any third-party contract here.
That's correct, Your Honor.
Okay. All right, thank you.
That is correct. All these people were state employees, whether they were directly employed by the state or by the agencies for the state. I think it's semantics. They were all state employees in one form.
Would the contractual obligor, if I've got that right, is the state, not some third party?
Well, I believe ultimately that's correct, Your Honor.
Okay, thank you.
Speaking to the right.
Can I also just clarify, what is your response to the argument that there's no evidence in the record that offering the 70-30 plan premium free is value-wise, actuarial value-wise, just as good as what these employees had when they retired or when they signed up for this contract?
Well, to speak specifically, there's actually nothing in the record, Your Honor, that deals with what the 70-30 plan value was starting in 2009 or 10 or 8. And I believe that's the state's argument they made in their brief, is that the indemnity plan that ended when there was a transition from the indemnity plan to these PPO plans, that somehow is where the equivalence has to be marked. But there is actually nothing in the record showing what the 70-30 plan's value was at all on either side.
Isn't it your burden, if we agree with you that there's a contract created, isn't the second step of the analysis, isn't it your burden to show that it's been materially damaged in some way?
And yes, Your Honor, we believe that it has been damaged because the value of that plan was reduced. There's both sides actually agree that the 70-30 plan was materially less valuable, less beneficial to the retirees than the standard regular plan that the legislature actually, by statute, there was a session law they passed in 2007 323, that actually said that all people who were on the old indemnity plan in 2008, which was originally the plan, regular state health plan, were to be moved to the standard plan, the 80/20 standard plan. And so I think that the record is clear that that was the intention of the legislature, was to move these people to that plan. And in fact, that's what happened. The problem started in 2011 when, for the first time ever, the state started to charge a premium for that plan. That's something that had never been done. And that was really the impetus of this suit. And that's something the state has really not addressed, is how they can charge premiums for that plan that has always been premium free, was always offered and promised premium free. I do want to deal with one other question. Looking at the pension statutes, they don't also use the word vest or contract in their primary provisions. So if you look at those, they're not materially different than what you have here, which is an eligibility provision, a period of time to perform your employment, and then ultimately you get the benefit. That's all that we're asking for, the things that we're
Mr. Carpenter, your time has expired.
Thank you, Your Honors. We would ask that you reverse the Court of Appeals and reinstate, remand this case to the trial court for reinstatement if it's well thought out order. Thank you.
And thank you, everyone. Madam Clerk?
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court. Thank you, counsel.